The Milwaukee judge who was arrested for protecting the due process of an undocumented immigrant in her own courtroom now is using a very interesting legal argument as to why she cannot be prosecuted by the Trump administration. Milwaukee District Court Judge Hannah Dugan has decided to use the Trump defense. What is the Trump defense? Saying that, hey, you can't punish me for an official act because I have immunity. Okay. Now, Dugan was indicted on Tuesday for allegedly concealing a person from arrest as well as obstruction. Okay. A day later, her lawyers argued in a motion to dismiss the case that Dugan is no ordinary criminal defendant. Now, she's got immunity. The motion argued that the problems with the prosecution were legion, including the fact that they allegedly violated the Constitution's fundamental principle of federalism, but most immediately, they said that the government cannot prosecute Judge Dugan because she is entitled to judicial immunity for her official acts. They even cited the 2024 Supreme Court case, Trump v. United States, in which the court ruled the president had absolute immunity for official acts. The 6-3 ruling involved Trump's criminal prosecution over his attempts to overturn President Joe Biden's 2020 election victory. Now, that case, however, did not provide a standard for what counts as an official act, nor did it determine whether any of Trump's individual actions fell within that category, saying that only the lower courts needed to consider the case in light of the sweeping immunity afforded to the president. Dugan's motion argues that that same standard should apply not just to the president, but to the judiciary as well. Immunity is not a defense to the prosecution to be determined later by a jury or a court. It is an absolute bar to the prosecution at the outset. In dividing official from unofficial conduct, courts may not inquire into the president's motives. Because Dugan's instructions within her courtroom constituted official conduct, they concluded that she is immune. Judge Dugan, therefore, has both immunity from conviction and immunity from prosecution. Gotta love that. Using the Supreme Court's own justifications of protecting Donald Trump in their own case. Now, the motion also denied that Dugan had directed the defendant to leave through the jury door so he could evade ICE agents. But even if she had, they said judges are empowered to maintain control over their courtrooms, specifically, and the courthouse generally. Not only that, but as I mentioned before, there was also the issue of due process. Okay, ICE didn't actually have the correct kind of warrant. They had an administrative warrant, not a judicial warrant. Now, what's the difference? Well, an administrative warrant does not give ICE officials the authority to enter private places without consent. But wait, hold on. Is a courtroom considered public or private? Now, you would think that it would be public, right? Well, it turns out nobody actually has an answer for that. Yes, there are public buildings, and the public has access to them. But a judge can also make these hearings private to protect the identities of certain people, for example, minors, or to ensure that there is a fair administration of justice. So, is it public? Is it private? Not sure. It depends, I guess. And not only that, but you also have the due process of the immigrant to consider. Okay, Flores Ruiz. And so, is his arrest, is that violating his due process? These are all important questions, okay? But back to their main argument, which is judicial immunity. Their complaint cites other evidence showing that judges have enjoyed immunity for official acts, even dating back to the 17th century in England and carrying on through U.S. common law. Oops. Yeah, so there you go. There's precedent here. Judicial immunity. Haven't you heard? You can't come after me. I'm immune. Look, here's the thing. Even leaving this argument aside, the Justice Department has a pretty flimsy case. All right? Not a good case at all. For example, Washington Elections Commission Chief Ann Jacobs had her own analysis of the government's complaint and found that far from obstructing the arrest of Flores Ruiz, the jury door she ordered him to go through actually led directly into a hall filled with federal agents capable of arresting him, and those agents chose not to do that. At least until later, okay, when Flores Ruiz and his attorney were already on their way out of the building. In fact, here's something comical, okay? So Flores Ruiz and his lawyer, they get into an elevator outside the courtroom, and a DEA agent that was there to arrest him literally gets in the same elevator. And then what happens? Nothing. That DEA agent didn't arrest anybody. They just got off the elevator. It was a weird, kind of moment of, oh, we're in the same elevator, are we? Oh, I'm kind of supposed to arrest you, but then I don't know if I can right now. I'm not going to. And so, oops, not until later. Now, knowing that, trying to paint this as a way to say that the judge was purposely hiding Flores Ruiz from these agents is ridiculous. She sent him into a hallway filled with these people. And Jacobs also noted that her arrest was, quote, wholly unnecessary and certainly appears to be designed solely to intimidate. Very unfortunate. And Jacobs was also joined by more than 150 former state and federal judges who had signed a letter to Attorney General Pam Bondi saying that Dugan's arrest is nothing more than an attempt to intimidate and threaten the judiciary and a cynical effort that undermined the rule of law. Well, yes, that is the point. That said, perhaps these people should have sent a letter to Stephen Miller, who was actually running the department. Okay, Pam Bondi is just the pretty face in front of it and is completely deferring to the White House and Stephen Miller. So, but here's the thing. It's actually kind of smart to use the tools that are presented to you. I mean, hey, if the president of the United States gets immunity for official acts, then why not the judges? Why not? Why should it only apply to Donald Trump? I mean, the Supreme Court didn't really think about this, did they? The ramifications of their decision. But, I guess that's what happens when you put a bunch of right-wing activists on the bench. It turns out they will make some pretty stupid, heinous decisions. I hope it comes back to bite them in the ass. Thank you for watching. If you enjoyed this video, please like, share, subscribe, hit the bell icon in order to get notified whenever a new video is released. And if you want to support independent, progressive media through this difficult time where it seems like everybody is shutting down, you can become a member on our YouTube page, you can become a subscriber on Facebook, or you can go to my Patreon. It's patreon.com/Jeff Waldorf. Thank you.